Wonderful. Good morning, everyone. Welcome, or good morning, good afternoon, depending on where you're dialing in from today. Good morning and welcome to Season 4, Episode 13 of ARBinBRIEF, a practical video guide on hand-picked arbitration issues. My name is Yasmine Fulena, and I am part of the ARBinBRIEF team and currently a legal intern with King & Spalding in Geneva. I have the honor of moderating today's episode on commodity trading arbitration demystified. We discuss the essentials with Juliette Asso from La Live in Geneva and Nhu-Hoang Tran Thang, founding partner of Astute Dispute Resolution, also in Geneva. Both have acted as counsel and arbitrator in disputes concerning commodity trading administered by a handful of institutions, and we're thankful to them both for their time today. Let's get started. Commodity trading is a sector defined by fast-paced, cross-border transactions with multiple actors. But Juliette, what is specialized commodity trading arbitration, and what distinguishes it from the more classic commercial arbitration? What institutions might be available to parties that are involved in these disputes?
So thank you, Yasmin, for this question. And actually, good morning or good afternoon, all, and thank you for joining the session today. So what is specialized commodity arbitration? You might have heard about it. So this is a specialized form of dispute resolution that has developed over time and which has become actually more structured and specialized for commodity trading. And what do I mean by commodity trading? I mean grain, metals, oils, sugar, coffee beans, mineral, etc. And this covers the whole chain. So it's not only buying and selling, but also transporting these commodities. So this is an alternative to ICC, LCIA, and other rules you might be familiar with. And there are some specialized commodity arbitration institutions that have created their own dispute resolution process. And they have their own rules, they have their own standard contracts. And you might have heard some names. There are plenty of them. I'm not going to list them all, but the two main are GAFTA, which is Grain and Feed and Trade Association, which is based in London. And there is also FOSFA, which is the Federation of Oil, Seeds and Fats Association, which is also based in London. And those two covers more or less 70% of London commodity arbitration. And London really remains, like this is important to know, London really remains the center of dispute resolution for many commodities. So what are the key features of these dispute resolution mechanisms? I've picked a few that for me like really strike me very different from what the sort of classical arbitration we are used to. So first, tribunals are composed of traders or commercial people rather than lawyers. And I must say this can sometimes create some risk of conflict of interest when the parties to the dispute are sometimes business partners with the tribunals. And I've seen that in some institutions, they provide for anonymous arbitration. So another feature is the short time limits for initiating arbitration, which are much shorter actually than the statutory limitation provisions. It is comparatively cheap compared to what we're used to, like an average of 8,000, very quick, an average of 8 months from start to finish. Another interesting feature is the multi-tier arbitration system. So you have the possibility to appeal an award. And usually what happens is at the first stage, there is no hearing. And you only have a hearing if you reach the appeal stage. And another feature is the fact that it's a multi-tier arbitration. That there are some strings contract and string arbitration. What is this? Is when you have a single commodity, and this is often the case actually in commodity tradings, when you have a single commodity shipment that is sold to multiple parties, instead of having different and separate arbitration, everything is consolidated into one process to ensure a consistent and efficient outcome. And then the award is binding on all parties, exactly as if you had one award in each separate contract. Another one which can also appear to us a bit strange is the fact that parties are not represented by lawyers in some institutions. And the last one, which I found a bit like it really struck me is some trade association employ a practice of what is called default posting, which means they publish the name of the parties of the companies that that default, that do not execute the award. So this is just to give you very quickly a brief overview of what is commodity trading, specialized commodity trading. And of course, commodity trading can also be resolved through like the normal like classical dispute resolution process. That's actually most of the cases I've had, and I think Wanga also had, were more like ICC case, Swiss rules, and a lot of Swiss rules in Geneva actually. And because these dispute resolution may provide further comfort to the parties.
That's really an incredible and very helpful, concise overview, Juliette, of the different facets we can find in specialized commodity trading arbitration. So Wang, turning to you and focusing on the commodities themselves that are at the heart of these disputes, what issues have you seen that come up with respect to the goods that can lead to disputes or their transport as they're going from one place to another?
Well, thank you very much. And I take the opportunity to thank you, Yasmine, and thank ARBinBRIEF for the invitation to speak about arbitration in an industry that I find very captivating in the sense that there is a very wide array of disputes along the supply chain that includes the transport, as Juliette said, and also because this concerns goods, that are very essential to our daily lives. So to answer your question about the goods themselves, so like one obvious issue that we may have with the goods is their quality, right? So you can have you have a lot of disputes that arise from the quality, out of the quality of the goods, and these defects in quality, they can be inherent to the goods, they can exist. And a lot of the disputes battle is actually whether it was existing, before shipment, or also whether the quality defect arose during the shipment. And to tell you one anecdote about a case I had with an inherent defect. It was an ICC case with sit in Geneva. And I acted as counsel for a Turkish buyer who had bought some Chinese origin steel. And the defect there was that there were bubbles, like holes inside of the bars of steel that our client purchased. And our client was purchasing these steel bars to manufacture, the construction steel rebars, these little bars that are reinforcing the structure of walls and all the structures in concrete and so forth. So the fact is that because of these holes inside of the bars, that are a bit square, when it was going into the production line, this would actually jump off the line and split in two. And the fun part for the lawyer was that we went to the factory to film this, to film how the production line worked and how it was actually creating a huge safety hazard, because you had the molten steel jumping in the air, and it was very impressive in the video. And you had distorted pieces of steel that we could bring to the hearing. And because for our client, the end result was that it was not only a safety hazard, but it was also like unusable for the purpose, because you cannot create reinforcing rebars with steel that is actually super fragile inside. So basically it had to be resold as scrap metal, on a secondary market. And I think Juliette will touch upon, the compensation issues in commodity trading. So I think that it's nice for the lawyers because it's very concrete, the cases that you see in this industry. And aside, I mentioned this, aside from the inherent defect in the goods, as I mentioned, you have a lot of defects that can arise during the transport, right? So it can be because of a wrongly done fumigation, before the transport, the vessel departs, you have to fumigate, like they do sometimes in planes for insects. And when it's not done properly, when the shipment arrives, you can have it goes very fast, so it's completely infested, your cargo. And you have issues like this. You have, for instance, if we keep the example of the steel, you know, it can be damaged just because it's handled roughly when it's in bulk. Or of course, another very evident issue with steel will be the rust, you know, if there is some water ingress or condensation during the transport. So if you have a dispute that comes to default, that you don't know where it happened and you're not sure whether the goods were good at departure, it's going to come down to inspection reports, sampling and testing, annotations on bills of ladings. There are a lot of tests, you know, being done, sometimes even during the transport. I mean, at some ports, you know, if they stop in some ports. So this is the kind of documents that you're going to work with, you know, in this kind of disputes. And of course, also we spoke about steel, but I mean, of course, if you think about rice, coffee, wheat, those are much more fragile, right? So they can also be contaminated because the tanks, you know, were not cleaned properly. So if you put like rice after fish oil or fish sauce, I mean, you may have like issues of contamination this way, you know, because of improper cleaning. So lots of very concrete circumstances that can give rise to disputes. And just to mention, you may also have actually quantity disputes, and they can arise from again many facts, but notably the fact that the way to measure, you know, weight in particular can differ from depending on the places. And for instance, if you take like crude oil, you know, there can be some evaporation during the transport. So you may have also disputes, you know, fighting on the quantities. Actually, when it's in bulk, you sometimes have a range, right? You have plus or plus minus a certain margin in which you can vary. So for all of this, again, like inspection report, testing, sampling will be your working tools. Now, to answer your question about shipping, the fact is that there is a whole universe of maritime and shipping arbitrations, which are involved, you know, the disputes that arise really under the contracts for the carriage of goods. And I'm thinking mostly about the charter party between the ship owner and the shipper. I mean, so the seller, if you want. So these contracts are often, if not always, governed by UK law, and they often, if not always, provide for London Maritime Arbitrator Association arbitration. So this is a particular type of arbitration, but the fact is that you cannot really separate, you know, the transport from the sale. And as if you're a lawyer who does like more standard arbitration, you may have issues of transport even if you're under the sale contract, because in the sale contract they would have put an Incoterm, but sometimes it doesn't align well with the charter party. Like to give you one anecdote that I had a case which was ICC sit in France. I was acting as sole arbitrator, and the issue was that for the shipping, the vessel was too long. The parties had envisaged the issue, but in the end, the vessel had to be rerouted to another port, and the whole question was like, who is responsible for these additional costs? And it was very much reconciling the Incoterm modified by the parties in the sale contract and the charter party. So yes, these kind of issues you may see.
That's an unbelievable, again, complex set of issues that were presented to us very, very concisely. Thank you, Hoang. And I hadn't even thought about the fact that thinking about the containers and what they had before, after, and what commodities are going in before and after could affect the good as well. So just a quick note, I do notice some folks are posting questions and answers, questions in the chat box. Can I ask that you just take a quick note of your question? We'll have a second session after this, starting in about 10 minutes or so, maybe a bit under 10 minutes. The link to that Q&A section has just been posted in the chat. Please take a note of that link and the passcode, and then please follow us into the question and answer session, and we can address those questions then. So now we'll go back to our discussion. Juliette, turning to you, we talked a bit about the commodities and what can lead to disputes because of the commodities. Can you share, based on your experience, what you've seen with respect to the contractual issues and what within the contract can lead to a dispute? And when that does happen, what remedies are the parties seeking?
Yes, thank you, Yasmine. And actually, when I've been preparing for this, I was trying to put myself in your shoes. I don't know if you guys are more like lawyers or in-house counsel, but I was trying to think what are like the main issues they want to know that if you have a commodity trading case, like issue that regularly come. And what I've done is from some of my case, I've tried to pick the main issue that I see often, like come very often. And so the first one I want to talk about, it was a case regarding the trading of steel. So steel that was shipped from Russia to the US. And this was actually a Swiss false case, and I was a counsel. So it raised the issue of wrongful termination. And this is something that very often arises in commodity trading arbitration, because as market prices are exposed to significant fluctuation, you often have one party to the contract who has an interest in terminating the contract, because sometimes you can have very significant fluctuation. That's an issue that comes very often. Another one that comes very often is the question of interpretation of like when and where the goods must be delivered, whether it's the date of shipment, the date of arrival. One mentioned earlier the Incoterms. It really depends. Sometimes really need to check those. Another interesting issue, which is very specific, I feel, to the commodity trading arbitration cases I've seen, is the remedy. So here, in these cases, you often ask for specific performance, which normally in kind of classical arbitration, you often ask for money. Here, you often ask for specific performance, which is, for example, taking the paying the price and taking the delivery, because it has a cost to keep the goods. And this leads me to another issue. Another type of damages that are claimed in these kind of cases is collateral damages. What is collateral damages? If you're in a situation, for example, where a party terminated the contract, and then the goods are already on a cargo, then you are or they're somewhere else in a warehouse, until you're able like to sell them to another party, you have all the costs of maintaining and keeping all those costs. And this is these collateral damages is often claimed in this type of cases. I have another one. It was in another case. This one, it was the sale of corn, which was to be shipped to Dakar, and this was an ICC case. And in this case, I was an arbitrator. And it raised the issue of demurrage cost, which is a very, very specific issue to commodity trading arbitration. And what is demurrage cost? Is basically the charges that are imposed when a vessel exceeds its allocated time for loading and unloading in a port or a terminal. And these are very, very important costs. And it's in other words, it's just a penalty that is imposed on the party, and beyond the free time that you're allowed to unload and load your shipment. So in arbitration disputes related to commodity trading, demurrage costs often become a contested issue, and very often, because there is often a disagreement on the responsibility for the delays. So the delays may have resulted from port congestions, from custom clearances issues, from bad weather, or problem with the cargo readiness. And so often the question is, who is responsible? Was the delay foreseeable? Was it avoidable? Or was it caused by one party's negligence? And I don't know, Yasmine, if I have 1 minute to mention in last case, or whether we need to move
Yes,
to
of
the
course.
Q&A.
Please go ahead with the last
Okay,
one. Yep.
so one last case, which was another issue, was still the trading of steel. As you can see, the steel trading, at least in Geneva, we are facing many cases of steel trading. So it was the sale of wire rod coils from a Swiss company to an Albanian company, and this was a Swiss wolf case, and I was an arbitrator. So one of the party wanted to terminate the contract without reason, as again, same scenario as earlier, the market prices had fallen. And the other party said it could not because the goods had already been shipped. But as the buyer refused to pay, then as an emergency, the seller had to sell it to another party at a very discounted price. And this is what you often hear the term distress cargo. This is what is a distress cargo. It's cargo that is shipped and you need to sell it very fast and the reason is why every day on a cargo costs so much money that it's not worth keeping like traveling the world until you find a buyer. And so in this case, the kind of remedy that was asked is to request damages to pay the difference between the original price and the discounted price.
This is really fascinating. I think we were fortunate that both of you bring such enthusiasm and energy to the discussion. It's clear that you both are very interested in this topic. We have, of course, only scratched the surface, but so we are unfortunately at time today. Please, for those of you who are joining us on YouTube, joining our discussion, please take note of the question and answer link in the chat box, which will open up a new Zoom discussion. We'll continue our discussion there in a more informal setting. But let me take this opportunity to thank you both, Hoang and Juliette, for our discussion today. I would also like to thank our partner organizations for Season 4, the ERA Pledge and the AAA ICDR Asia Case Management Center, for their invaluable support in making Season 4 possible. We're, of course, also truly grateful to those who supported the marketing of our episodes throughout the year. For those new to ARBinBRIEF, please make sure to follow our LinkedIn page and subscribe to our YouTube channel, which is where you'll find more information on our upcoming episode. Thank you so much for joining us. And for those watching us on YouTube, our video does end here. For those joining the Q&A session, in case you missed it, the link is in the chat box. Please join us there. See you all soon. Thank you.